Okay, so I'm Tracy and Amanda is also here, who is a member of our team. So we'll be watching the chat and answering any questions that you've got. If we do miss anything at all on the chat box, just give us a quick prompt because it doesn't always show massively clearly in front of us. So today we're talking about sexual harassment, discrimination, and unconscious bias. So as you probably can tell, they're three quite big topics that, to be honest, could all be a session on their own. So we'll give you a quick kind of run through on of each of them. And as with all of the other sessions, if you've got any questions, feel free to jump in and ask. If you've got any comments or experiences you want to share, like we say, if you'd rather wait till the end when the recording stops, that's absolutely fine too. So what we will look at today will be sexual harassment and discrimination, a reminder of the Equality Act. We'll have a little bit of look at vicarious liability and what reasonable adjustments you might want to make. And we will look at when discrimination can occur. So at what stages can discrimination occur? And how does that then tie into your own unconscious biases and how you may perceive or react to certain situations? So, sexual harassment in the eyes of the law is defined by the Equality Act 2010, and it's an unwanted conduct of sexual nature which has the purpose or effect of violating an individual's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. So that's its legal definition. Sexual harassment can include a number of things. So it could include physical contact, it could be things like sexual jokes or comments. Sometimes it can be sexual advances. These days, increasingly, things like explicit messages, emails, texts, or graphic images. But it's really important to remember that it's a really wide spectrum of what sexual harassment is. As with any other type of harassment, the important thing here is how the individual perceives the treatment. So the person who is doing the harassing, who is sending the comments, sending the texts, may not mean to be sexually harassing somebody, but the recipient may feel that they are being sexually harassed. And that's the really important thing to remember, is it's about feelings. And as with anything of this nature, what offends one person may not offend another. So all of this is on a spectrum and a scale. Um, there have been some changes around sexual harassment, and for those of you who are on our mailing list, you would have seen these coming out. So going back to October 2024, so about 18 months ago, there was a worker protection amendment to the law. And that basically focused on how companies need to manage sexual harassment. So the situation right now is that it is no longer enough to just deal with sexual harassment problems when they arise. Going back prior to 2024, that would have been absolutely fine. Somebody reports it, you would deal with it. Now you are required to proactively prevent the sexual harassment from happening in the workplace. So you need to assess your workforce, you need to understand where your risks are, and you need to take measures to proactively prevent it from happening. Where sexual harassment does occur, you need to evidence how you've stopped it happening again. So, what actions have you taken? What measures have you put in place? As with a lot of things that we talk about on these sessions, this comes down to documentation. So, a lot of it comes down to evidencing the risks that you've identified, but equally importantly, if not more importantly, identifying how you have taken action when you have needed to. There was another change to sexual harassment this year. So prior to this April, sexual harassment was part of an internal grievance. It never formed part of whistleblowing. From April of this year, sexual harassment itself can now be classified as a whistleblowing protected characteristic. Now, what that means in reality is if somebody has raised a concern of sexual harassment prior to spring this year, you would have dealt with that internally, but it wouldn't have given them any rights to take you to tribunals for unfair dismissal or to take any further action. Whistleblowing has always been one of the caveats that even with less than 2 years service, somebody can take you to tribunal if it's connected to whistleblowing. And sexual harassment now forms part of a whistleblowing protection. So another risk to businesses, and another protection quite rightly for individuals. But if you do have a sexual harassment case and you subsequently dismiss that person as a result of something connected to that case, they can take you to tribunal even with less than 2 years service. Just looking at some figures and stats. So current figures at the moment show that around 3 in 5, around 60% of women have experienced sexual harassment at work. And that includes bullying or verbal abuse, so sexually related bullying. In women between 25 and 34 years old, that figure rose to 66%. So a really high number of women that are experiencing harassment at work. The figure always tends to be higher in women experiencing sexual harassment, but it's important to remember that men can also be sexually harassed. And don't fall into the trap of viewing this as something that, stereotypically men harass women, because that really isn't the case, and there are equal number of stats showing sexual harassment cases amongst your male workforce. So what are you required to do as an employer? You're required to proactively mitigate and prevent sexual harassment from occurring. So it's not enough to just address issues when they happen. You need to try and stop them happening in the first place. Sexual harassment is one of the areas of the Employment Rights Bill that is a thread throughout all of the changes. So in every year's law changes that are coming up, sexual harassment remains a focus throughout all of them, and the protection is getting stronger and stronger. This legislation will cover, or does cover, employees, workers, and third parties, which includes customers, clients, suppliers, public service users, pretty much anybody you come into contact with. Now, that protects your staff from being harassed, but it also protects members of the public or your suppliers, your contacts, from being harassed by your staff. And very often, sexual harassment cases come about because of banter. People think it's just banter, it's just sort of how we work. But do remember that if a third party were to be offended by that, that could also open up another claim. The third party harassment at the moment doesn't give right to a standalone claim, but it may be part of another claim. So that means your third parties can't take you to court purely on the sexual harassment. But remember that with this change under whistleblowing, potentially your staff can. Um, Where you have found a breach in the legislation, you need to consider the level of risk and then deal with that appropriately internally. And you must keep records of any breaches. So if you have a sexual harassment claim made to you that you subsequently investigate and that leads to disciplinary against a member of staff or anybody, you need to have records of how you've dealt with that, how you've mitigated it, and what steps have you put in place to stop any potential reoffending. And it's really important that you keep those records. So when you're thinking about managers and employees, think about different types of harassment. We're talking about sexual harassment today, but there's lots of different types of harassment, which also tie very often into victimisation. Make sure that your staff know how to raise complaints. More importantly, perhaps, or equally importantly, is make sure your managers know how to manage complaints, because there's nothing worse than a member of staff plucking up the courage to raise something for it then just to be brushed under the carpet and nobody knows how to deal with it. Think about what records you need to keep. Think about support that might be available for complainants. And think yourselves as a company as how can you identify potential cases. You may notice changes in somebody's performance. You may notice changes in attendance, lots more absence or avoiding working in a particular department, for example. It might show through resignations. It might show through comments on staff surveys. So just think yourself about how you can be alert to what could be causing some of these issues. We do have a risk assessment and some different templates relating to sexual harassment. So all of our customers will have seen those, but if you haven't or you want access to them, just let us know. But one of the most important things, like we've said today, is identify the risk and mitigate the risk, but don't wait until it happens to take action on it. When you're doing your risk assessments, you might want to think about particular areas of the business, particular risks, staff who are night workers, staff who are working in environments where there's alcohol, perhaps staff who are lone working or community working. So there may be certain jobs that are more at risk than others. Think about banter. Like we say, banter is to blame for a lot of the problems that occur. Think about inclusivity and respect. So consider your gender balance, your equality, think about your policies, think about how you manage all of these kind of things. Third party interaction. So if you've got staff that are liaising with clients, with customers, with members of the public, are they aware of how to also speak to them and how they can expect to be spoken to themselves? Think about managers training. Have you got access to raise concerns? Have you got an open environment where people can come forward if they're worried and raise concerns? Communication obviously is throughout all of this. So think about how you communicate this internally and how do you monitor trends? How will you know, that a case has been raised? Obviously, remember that with the introduction as well of the Fair Work Agency, who have come into force since April, you may be asked for records on things like this as well if ever you are audited. So do keep your documentation up to date. Just a final reminder on sexual harassment, you must take all reasonable steps to prevent it. This extends to everybody that you come into contact with. And if a tribunal found that you failed to prevent, there is a 25% tribunal uplift. So this can be an expensive mistake as well as obviously a very difficult one for staff and businesses. So that's the end of sexual harassment. Has anybody got any questions before we move on? If so, feel free to just pop your mics on or pop them in the chat. We'll have a quick look at the protected characteristics. So lots of you know this slide. This comes up in a lot of our training. There's 9 reasons in the UK which are covered under the Equality Act as being the areas that form discrimination. And that is age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. So they are the areas that form discrimination in the UK. There's different types of discrimination you might face. So just as a refresher, your direct discrimination is very direct, very obvious who you're discriminating against, i.e. a job for a woman, a job for a young person, a job for a Saturday girl, very clearly discriminating against somebody. Indirect discrimination is a little bit less easy to spot, but may discriminate against a particular group. So a role which requires Sunday working may discriminate against those with religion or faith who are going to church on a Sunday, perhaps. If you advertise a job which must be worked between 7 and 9 in the morning, you may well rule out sort of your school runs, your working parents. Associative discrimination is discrimination by association, and that's where you treat somebody differently because someone they know or somebody they are associated with is protected under the Equality Act. Now, this is where a lot of the banter comes in, and especially in sexual harassment claims, you may have, for example, a very male-dominated or a very female-dominated workforce who regularly make comments about the opposite sex. Now, lots of companies will say to us, well, nobody's offended by that because we're all men or we're all women. But it's really important to remember those people will all be connected to somebody of the opposite sex, and they may well be offended by that. And then vicarious liability is where the company is held liable for the acts of its employees. You may have an interview panel, for example, where one of the interviewers makes a comment about, oh, we don't have many women here, it's all men. We've never had a woman in this team. That may not be the view of your company at all, but that comment could mean that you are held liable for that comment being made. So the person that's on the receiving end of it won't think, well, that isn't the view of XYZ company, that's only the person that said it. It will tarnish your company's reputation. So just think here about what your staff and what your managers may be saying that could come back to you in terms of being represented as your own views. Just some stats that we're going to look at now, just around some of the disability and some of the protected characteristics. So 23%, 1 in 4 working age adults are currently disabled, and there are 5.1 million disabled people at work in the UK. The employment rate of disabled people is 53%. Now, as we said earlier, disability obviously spans a huge scale from people with a disability where it doesn't have a major effect on their life to those who are very severely impacted. But when you look at these numbers, it is very, very statistically likely that you have people in your businesses, in your teams who are suffering with a disability. Some disability relates to neurodiversity, and a recent study showed that 78% of neurodivergent workers regularly feel overwhelmed at work. I mean, it's a massive number of people who struggle to function or feel overwhelmed at work. And when you are looking at your workforce or perhaps considering things like progression, training, make sure they are available to everybody and they are sort of, they are equal really to all staff. Mental ill health, the same kind of trend on figures. So 1 in 4 adults will or is experiencing mental ill health. And again, that can affect from very low level effects through to really serious symptoms. The number of people or number of workers who report their mental ill health limits the type of work they can do has quadrupled over the last decade. So a massive shift in the effect of mental health on employment. And it is currently the most common cause of work limiting conditions for those aged 44 and under. So it is having a really big effect. And again, when you look at those numbers, it's very likely there will be people in your teams or in your businesses who are suffering from mental ill health. And then another area to consider is menopause. Now, menopause isn't a protected characteristic in its own right, but very often is linked to disability or sex discrimination or even age discrimination claims. And there are increasing cases going through court. relating to menopause related discrimination. So just some stats around menopause there. So nearly 8 out of 10 women, 80% of women will go through menopause whilst they're in employment. And 67% of those women feel that that has had a negative effect on them at work. 53% of women will be absent at some point because of it. However, worryingly, only 11% are happy to talk to their manager about their symptoms. So this comes back to what we were talking about earlier around communication, and creating that kind of open environment. And again, just a reminder there, menopause can range from everything from very low level anxiety or low mood through to really serious symptoms that people may suffer. So the one bit of advice we would give around managing any of these types of groups is don't fall into the trap of thinking, well, I've got three ladies going through menopause, therefore they all need the same. Or I've got three people who are neurodiverse, I'm going to treat them all the same, because what they all need will be completely different. And it's also important to remember that it will change. You could do a risk assessment on a disabled member of staff, for example, today, but their symptoms and their need will change. So don't fall into the trap of thinking, well, that's fine because I've done a risk assessment, because what they need today may be completely different to what they need in a couple of months. Um, so with regards to the Equality Act, so anybody who is protected under the Equality Act has a legal right to request reasonable adjustments. Now, it's important to remember that doesn't mean you have to implement them, but it does mean you have to consider them. Now, those reasonable adjustments could be anything such as break times, it could be amended hours, it could be amendments to location, it could be more regular support meetings, more regular one-to-ones. And as we're saying with all of this, when you consider an adjustment, whether you agree it or don't agree it, keep your documentation to evidence why, because that's the really important part that will show that you've given it due consideration and you've made a reasonable decision. And the bottom box there is probably the most important one out of this, is what's reasonable for one business may not be reasonable for another. So when you consider any request, consider that against your own business, the constraints that you have, the flexibility that you have, but treat each case on an individual basis. When you're looking at adjustments, it's really important to identify what adjustments may be needed. Consult with the worker, have an open conversation around what they need, how you might be able to provide it, how would that look in reality. Research your options, get some professional advice if you need to, and then make a decision and review that as you do, as you go on. We've talked there about a reasonable adjustments passport. Like we say, that really isn't any more than your documentation, but do keep notes of what you've discussed so you can access it, the person can access it, but more importantly, you can refer back to it in the future. Now, when you're doing risk assessments, you can do that obviously one-to-one with the person and sit down with them and think about the risks that are posed by the whole of their role. So again, don't fall into the trap of thinking, well, I know that they're okay doing this part of the job because I see them do it every day, because that doesn't mean that they're not struggling with it. So have that chat around the role. What are the problems that may be facing and what adjustments could be made to support them in that? And think wider than just the actual job they do. As we said earlier, you might want to think about the work environment. You might want to think about support, things like noise in the office. Have they got a quiet space? Could they wear ear defenders? So have a think around all of those areas. Now, when can discrimination occur? The answer is it can occur anywhere. It can start off with applications. So before you've even employed somebody, you can be held liable for discrimination. Very often it happens through recruitment and selection, interviews, and then once you appoint, it can happen through your day-to-day management. It can happen through things like pay rises, promotions, redundancies or change management. And when you're looking at each stage of a process, just ask yourself what type of adjustments might be needed. Are we making this process fair to everyone? And when you're thinking about fairness, this is a slide that we often talk about in training. If you offer everybody equality, you're going to give everybody exactly the same. As we've seen through these stats and these figures, everybody doesn't need the same. They need something that's right for them. So this graphic here just shows that, if you give every member of staff 2 boxes to stand on, your tall people are still tall and your small people are still small. So actually through risk assessment, you will identify who needs extra support and who doesn't need the extra support, and make those adjustments personal to the individual. So we'll have a quick look at harassment and victimisation now. So under the Equality Act, there's 3 types of harassment. And that is harassment relating to protected characteristics, which we talked about a moment ago. There's sexual harassment, which is its own category. And there's also less favourable treatment as a result of harassment. So if somebody is harassed and as a result of raising that, they carry on being harassed, that is also a protected characteristic. And then victimisation is slightly different. This is where somebody treats you badly or subjects you to a detriment because you complain about something or you help somebody who has been a victim. So very often people fear raising concerns because of a fear of victimisation. And it's really important as a company that if you deal with cases of harassment or you deal with any cases of any kind of unfair treatment, that you make sure that the person who has raised it is treated carefully and properly going forward, but also that people aren't penalised for speaking up. And sometimes people will speak up wrongly. Sometimes people may raise concerns of harassment that actually turn out to be unfounded. But as long as that's been raised in good faith, it is really important to carry on treating that person fairly, because there are really big risks of victimisation if you don't. We're going to move on now to looking at unconscious bias. Again, has anybody got any questions around any of the harassment before we move on? Just pop them in the chat if so. So unconscious bias, it's really important to remember we all have a level of unconscious bias, and that is in all of us, and it's built through our life experiences, through our contacts, through our upbringing, and it can quietly influence our perceptions and our decisions. Now, you can have the best intentions in the world, but you will always have that level of unconscious bias kind of underneath them. And this can affect things like how you view other people. It can affect your beliefs and views. Um, it can make you feel better of somebody because you think you're like them or you have a shared interest with them. But more often, it makes you feel less of somebody who you think is different. And that difference may be visible. It might be a different race, a different religion, a different age, a different gender, or it might be a perceived bias, like, we don't employ women here, or we don't employ young people in our team, and it can actually stereotype against a whole category of people. What this means in reality is that your decisions could be influenced by false beliefs or false assumptions. And as I said a moment ago, often this is stereotyping. Unconscious bias is stereotyping. It's really important as a manager to be aware of your biases and not to let that affect how you run your business. So there's different types of bias here. Affinity bias is where you have a preference for people who are similar to you. Very often we hear of companies who want to recruit because somebody's left, but actually what they're looking to recruit is exactly the same. It's another man in their 40s of this religious group or, this political belief, and that may not be what you need. Beauty bias is about physical appearance, and very often that comes into things like not employing somebody who has tattoos or judging somebody with a particular hairstyle, for example. And then your confirmation bias is around beliefs. If you've already made up your mind about somebody, it doesn't really matter what they say in their interview because you're only going to pick up on the things that affirm that view or that belief. Gender bias obviously is very, as it says, treating somebody different because of gender. And very often when we're talking about bias, we talk about the halo or horns effect. So the halo effect, you only choose to see the positives in somebody because they're what you think you need. And equally, like say, if you've got that bias that, for example, you won't employ somebody with tattoos and you interview somebody with tattoos, you may only pick up the negatives from that interview because your bias is telling you that that's not the right person. So some sort of examples of what unconscious bias could look like: only socializing with people who share the same characteristics, not hiring somebody because of a physical kind of appearance, choosing to hire somebody because you're attracted to them. Now, that doesn't necessarily mean physically attracted, but it could be the stereotype. If you're hiring somebody for your reception desk, you want that to be somebody attractive. And those biases do still exist in business. Sometimes it's placing more value on someone's opinion because they're a friend. And we often see that where perhaps charities are recruiting for trustee boards and they tend to be recommended by somebody that's here. And there's that perception of, well, they must be good because so-and-so recommended them. That is a type of bias. Not including people in meetings or not including them in social events because of a perception around disability. So like I said, with bias, it's important to remember we all have bias, it's natural, but just be aware of what your own biases are and make sure that they don't affect your management decisions in a negative way. So to avoid it, consider how you recruit. it's best practice to advertise your job in at least two different places, for example. You know, if you only put your job into a professional journal, you will only attract professional people. If you only put your job into the school PTA, for example, you will only attract school parents. So just think about where you are recruiting people from. Train your managers. Again, this comes back to manager training. Make sure managers address and act upon inappropriate stereotyping. You know, they see it happening, they need to be acting on it. Anonymize your application forms or your personal details. Don't allocate full decision making to one person. You know, often on disciplinaries or interviews, there'll be more than one person on the panel. Again, make sure you keep your notes and your trends and manage issues in accordance with policies. Create that safe space where staff can raise concerns and come to you if they've got any worries. Okay, so that's the end of the information we're going to go through. We've got some case law to look at now. So a few different examples of case law that have gone through the courts relating to what we've talked about today. If anyone's got any questions, feel free to either pop your mics on or pop them in the chat. And if not, we will come back to them at the end. So case law here is, this one's against Barclays. This lady was working as an analyst between 2016 and 2020. And she had serious symptoms of endometriosis, which is a disease that affects the lining of the womb. And she also had a decline in her mental health. 2019, she began a period of sick leave, and that was around the time that the company announced redundancies, and she was subsequently made redundant. She filed two separate claims for discrimination, victimisation, and harassment, and she went down disability, race, and sex, and also an unfair dismissal claim. So, quite a lot of different claims that went to the court. As a result of being made redundant and being off sick, she had gone to her parents' home in Romania. So she lost her unfair dismissal claim because the tribunal said that there was no prospect of her actually returning anyway because she wasn't even in the country. But they did say that with regards to the other claims, Barclays couldn't evidence that they had taken steps to ensure that she didn't work longer than her contracted hours. And that was deemed a reasonable adjustment for her conditions. And they also said that her working environment made her uncomfortable and that the managers regularly referred to women as birds and used a lot of other terminology that amounted to sex discrimination. She was awarded £31,000 for personal injury, and the bank were held liable for exacerbating her endometriosis and mental health, as well as injury to feelings. So she walked away with £48,000 as a result of all of those things. Interesting in this case, they didn't give an award for loss of earnings, as the tribunal felt that there was a 100% chance that she would have faced the same mental and physical prognosis, even if the bank had made reasonable adjustments. So they penalised Barclays for not making the adjustments, but there was a comment made that even if they had made them, the same outcome would have happened anyway. So quite an interesting kind of twist on that one. We just got a quick question in the chat here is fibromyalgia classed as a disability? And if so, what adjustments could be made? It's a really good question. The legal definition of a disability is something which has or will affect you for 12 months or more and has a substantial effect on your day-to-day living. So it's very likely that fibromyalgia would be classed because generally speaking, people have it sort of for more than 12 months and obviously it can affect you. The kind of adjustments really would depend what the person needs. So it may be things like flexibility around start times, for example, if you're struggling with fatigue, perhaps the ability to work from home if you're having a flare up or a bad day. It might be additional support, you know, if you're struggling with certain aspects of the job. So lots of different things that could be assessed through the risk assessment, but it certainly could be classed, I would say, yes. Okay, and then the next case here is Vantage Capital Market. So a lady called Vajri. This lady had had surgery and chemotherapy for breast cancer in the summer of 2022. And she told the company she was planning to come back in January 2023. The company said they wanted her to do a medical assessment before she come back. So they effectively stopped her coming back pending this medical assessment. She did have sick pay reduced while she was off, but she didn't get any formal notification of that. It was a very casual WhatsApp from her line manager. She then emailed in November to say that she's looking forward to returning in January. You know, see you then. And they ignored that. So she emailed again to the manager and she emailed HR and she followed up on WhatsApp to reiterate this. On the 14th of December, she got an email to say that they needed a full report from the doctor. And they asked her then about her plans for travel clients. She replied and again was ignored. By February, she was, couldn't get hold of anybody, so she instructed a solicitor who wrote claiming disability discrimination. She had suggested at that point that she would go back 3 days from February and was still ignored. So in March, she resigned. Now, the tribunal awarded her £14,858 for disability discrimination. And they found that there was no reason for the company to be not responding to her texts, not engaging with her on the return, and the company were held liable for blocking the return. Now, in their defence in court, they were talking about the plans they were making around occupational health referrals and other things. But again, there was absolutely no evidence. So these cases very often fall down on the evidence. An NHS one here. So this lady had had 8 occupational health assessments for light and noise sensitivity, and she'd had a brain hemorrhage, made repeated requests to her employer to act on these recommendations because she was really struggling in the office. And some of the adjustments she had asked for here was to move to a quiet corner away from colleagues. The manager was really slow to respond. And when she asked him why, he said it was because he needed her to sit near him. She then had a week of sickness, and on a return, they gave her a different desk, but it wasn't in the quiet order that she asked for, the quiet area. And they also refused her to wear ear defenders because they said she would be unable to hear the phone and hear her colleagues. They did a risk assessment, and there were lots of actions identified, but nothing was agreed and no risks were documented. So the tribunal called it a pointless exercise. When reviewing timesheets, it was also commented in the risk assessment that she was working late quite a lot. And she said to the manager that she had to, because it was the only way she could get her work done in the quiet. And he had written a comment that it's because she was slow and that she had to do it. She was awarded £27,000 for discrimination and injury to feelings. So again, another case where they had followed the process. They'd done the occupational health referrals, they'd done the risk assessment, but nothing was implemented and documented following it. Just a couple more quick cases here for you. So this one is a sexual harassment case, so Story versus Tesco's. In this case, Lara Story, a personal shopper, brought a claim for sexual harassment, including physical touching. Tesco's upheld the grievance, so they upheld that it had happened, but the colleague who was found guilty of doing it remained in post, and they did give assurances that that colleague would be relocated. Story had repeatedly asked them to be moved because the working environment was uncomfortable, but that was also ignored. And on every communication, the managers just acknowledged that they were aware of it, but they didn't actually do anything about it. She logged a complaint to say that keeping the colleague working with her was a breach of equal opportunities and the disciplinary policy, and it failed to create a safe environment for her. In this case, it was settled prior to going to court, so they settled without liability, but they settled for £45,000. So a really big payout for a breach of its own policies, which were written and were documented, but again, they just weren't followed. And then just one more here. This is a DPD one. This is a sex discrimination one. Um, this is a man, Rawlings, who made a flexible working request to work 4 days a week due to childcare. It was approved in 2022 and he was given Fridays off. So he worked 10 hours Monday to Thursday. He got repeated comments, repeated banter, as we were talking about earlier, from from colleagues about his day off. They called him a part-timer. They told him he had Fridays off. He had a short week. And his manager also gave him lots of additional work, which didn't fit into his shift patterns. He filed a grievance in April 22 and then resigned in the October. And he raised a claim to the tribunal, who said that there was sex-based discrimination here. And their ruling was that it's unlikely to have been gossiped about if a female changed her hours or had a different working pattern to look after their baby. So they found that he was discriminated against because he was a man, and that it's very unlikely it would have happened if he was a woman. He didn't have 2 years service. So his claims for unfair dismissal were dismissed, but they did find that he had been discriminated against because of his gender, and he was awarded £20,000 in compensation. So some really big payouts on those cases that just kind of highlight the risk to your businesses. A lot of these are big companies that we're looking at today. So these cases probably wouldn't be enough to kind of cause catastrophic damage to them. But for smaller businesses to receive a payout of this kind of level, could be really, really damaging to your businesses. That's the end of the training. So we have popped a QR code on there as we normally do. If anybody's happy to leave a review, we would really appreciate that. What we will do in a moment is stop the recording, and then if we want to stay on for any discussion or to ask any other questions, you're very welcome to stay. Amanda, do you want to stop recording whenever you're ready?